All right. All right. Well, thank you, Chris. And thanks everyone for joining us tonight. We're going to talk about special needs trust and special needs planning. So we like to partner with community organizations and provide this information to the community. And I am actually truly honored to be on the board of UCP of Stanislaus County. So I get to hear a lot about all the great programs that are going on and experience some of that. So here's our contact information, and I'll put that up again at the end, so you don't have to rewind the recording or madly write anything down right now. But if you do have any questions after what you hear tonight, feel free to reach out, phone, email. You can check out our website, and then we are on social media platforms. So I'm Gina Leguria. I've been an attorney since '99 and went to McGeorge School of Law. Been doing this for a lot of years now, more than I care to choose, but I got into the business of estate planning because my own family went through a horrible probate after my dad was killed at the age of 42. So I went to law school just to do this, and have found my niche in my home and love serving families in our community and keeping them out of court. And with special needs children, you need to take that into account, especially as they grow older and you want to make plans for them. So we're going to talk a little bit about that tonight. And of course, the most important reason why I do what I do are my two girls who are, oh my gosh, 21 and 23 now. So my pictures are a little outdated, but they're spreading their wings and becoming good young adults in the world, thankfully. I'm a member of an organization, pretty fantastic actually, called the American Academy of Estate Planning Attorneys. And what this means for my clients is that I literally have colleagues in all 50 states. So if you have a loved one or a family member in Connecticut or Ohio or Kentucky or Texas, I have someone there that can likely help them or certainly get them a referral. So you can certainly share this information with those outside of California, although we're going to be talking about California specific provisions and trusts tonight. And our goal for tonight is, just to think about creating a life care plan. What happens when you're no longer here to care for your special needs loved one? And we want to talk about the options that are going to be available, and then how can we supplement and support and enhance a loved one's benefits, and then avoid those common yet very costly mistakes. So it can be very costly if you don't do this right, and avoid being unprepared. Avoid not having any plan in place and then having something devastating happen that really impacts your loved one and maybe even their benefits. So we're going to talk about your family goals and challenges, and then government benefits. I'm just going to give a brief overview because I'm not an expert in all of those programs. They tend to be highly specialized with a lot of their own rules and regulations. And quite frankly, I have found over the years that those of you that have lived through those programs, trying to get qualifications and recertifications and representative payee status and the like, actually know a lot more about those systems than the attorneys do. We only know what the regulations say, and boots on the ground, how it really works. We'll talk slightly about guardianships and conservatorships. And then some of the other unique planning options that are out there, like ABLE accounts and special needs trust, which is what I really specialize in is special needs trust. So we will jump right into that. So there are many different kinds of disabilities out there: physical or mobility related, cognitive, developmental, sensory, mental illness, and then oftentimes acquired disabilities. So many areas that this touches upon, and some of them you can't always see. I know that's hard for people to believe sometimes, but it's not always apparent. So we don't want to make assumptions or discriminate. And every disabled individual has a unique set of circumstances and a unique set of needs. Now, caregivers, as caregivers, you know that there are a lot of you out there. 53 million people provide care to an adult or a child, and about 14.1 million or so care for children with special needs under 18. So a lot of caregiving and unfortunately a lot of burnout going on out there. Now, despite the Americans with Disabilities Act in 1990, people with disabilities still face a lot of discrimination and unequal access to employment and housing and medical care and insurance coverage. And we certainly see a lot of that. I know just hearing reports about UCP's, efforts to find employment for some of our individuals. It's an uphill battle, and oftentimes you just want, somebody to give these folks a chance, give your loved one a chance, and they can do so much. So there's a lot of it out there still, discrimination. We always talk about the worst case scenario as an estate planner, as a parent, as an advocate. One of the things that part of my job is to educate people on what's the worst thing that could happen, and then let's plan for it. Let's try to mitigate that. So you have to think about who's going to care for and advocate for your child or your loved one, and who's going to make sure they keep their benefits, and then who's going to make sure that they have, an opportunity to lead a full and really a joyful life. You want to make sure that you have systems and safety nets and support in place. So we always hope the worst case scenario isn't going to happen, but I had a good quote. I know it's been around for a lot of years, but a friend reminded me about it. But failing to plan is planning to fail. And you won't be here to see the failure, but there could be devastating consequences for your loved one with special needs. So really, we want the family to, gather together to offer quality and life and happiness and just, overall having a good plan in place. So I'm going to touch briefly on those government benefits, like I said. So we have basically fall into two columns. Entitlement programs, things like SSDI and Medicare, and you are entitled to that. Those are entitlement programs. You don't really have to qualify. You have to be disabled, of course, but those are part of the government entitlement programs versus means tested. So means tested means you have to qualify due to circumstances and oftentimes income and assets. So SSI is one of those programs. Medi-Cal certainly has some eligibility requirements, in-home support service, Section 8 housing, and then TANF, temporary aid to needy families. And most of those programs are administered either through the Social Security Administration or our local here in Stanislaus County Community Services Agency and San Joaquin County Department of Social Services. They used to be called the Welfare Agency, but that's not a very nice term. So we talk about, community service or social service, but they administer a great majority of those particular programs. Now, with Social Security disability, you have to have been disabled before age 22. And then it can be based on the parent's record or a deceased parent's record, something like that. And then they get what are called CDBs, child disability benefits, or DACs. A lot of alphabet soup here. I'm not expecting anybody to remember this, and just, again, trying to give you that broad brush overview of what some of those benefits are. Then there's Medicare, and SSDI beneficiaries get that after 24 months of a qualified disability. So a lot of, like I said, regulations and processes to keep track of. It's good to have a relationship with somebody in Social Security who can navigate you through that process. And that's hard to do sometimes, but sometimes, they'll send you a caseworker, or at least try to be responsive to any correspondence they send you, because that means they're actually working on your file. So those means tested programs, SSI, Medi-Cal, IHSS, Section 8, TANF, those all have strict requirements in terms of income and assets. And we could talk more about that. I could, spend hours on that. But if you have a particular situation, I would simply suggest give me a call or shoot me an email, and we can talk more about the specific benefit programs that are available. But like I said, one of your best resources are your fellow parents and other people that have gone through this, because it can be quite a maze of bureaucracy and paperwork to make all that happen. Now I'm going to touch on just briefly conservatorships, guardianships, and we have guardian of the assets. So think of this as a person who holds the legal title for somebody who's unable to manage them. And then we have guardian of the person. So someone to take care of the child. A guardian for a minor is absolutely necessary. And the court will most often defer to the parent's will, but not always, depending on if there are extenuating circumstances. So there are two types of guardian conservatorship: one of the person, physical person, and then one of the estate and their assets. And those can sometimes be two different people or all the same people. And I know that some individuals are conserved. There's a lot of, different feelings about that, very strong feelings. But you should consider what is right for your family in your unique circumstance. And some considerations going along with that are the capacity of the individual to participate in their care and in managing their resources. And then whether or not there's a concern about having something that's court supervised. A conservatorship and a guardianship are court supervised, and they can be very burdensome and very time consuming. And I don't actually do the guardianships and conservatorships any longer. I have other referral attorneys that can handle those because they are so their paperwork and court date and hearing intensive. And so we don't specialize that anymore, but we do the planning on the front end to hopefully avoid some of those situations on the back end. There's not a lot of flexibility in a conservatorship and a guardianship because you are answering to the court all the time. But like I said, in some unique circumstances in your family, that might be appropriate to have a conservator appointed. But there are other planning options. So you don't always have to just default to the court. And if you do nothing, it may end up that somebody has to go to court to make this happen, in which case a conservatorship would likely come into play. So doing good planning on the front end may avoid the entire court thing on the back end. So I always say these two things are absolutely not recommended. And I unfortunately have parents in here all the time who give their money away to other charities, causes, people. They just give the money away, or they disclaim the inheritance or gift. So it's not just parents, it's individuals. So if you inherit something, and I get these calls all the time, oh my God, I'm going to be disqualified from my public benefits. What do I do? And so we have to scramble quickly and figure out what some of our planning options are. But you can be disqualified from public benefits if you accept the money and then give it away. And oftentimes you can be disclaimed if you are named in a probate and you disclaim it or you want to gift it out. They will oftentimes count that against you. So we want to make sure that we have other planning options. And when it comes to parents, I say, don't just outright disinherit. I have parents who often say, well, I'm just going to give it to their older brothers and sisters and they will take care of them. Well, we hope and pray that that happens, but hope and prayer is not a strategy. So we need to make sure that we have something in place that is our plan to protect that loved one going forward. Some other options too are spend down. So if somebody did inherit the money, we could do a quick spend down on things that are allowable. So, housing, buying a home, you're allowed to own a home, oftentimes a vehicle, there might be medical expenses. So that could be an option. And then there are ABLE accounts. And then of course, special needs trusts. So those are just some of the options that are available. So as I mentioned, disinheriting, the upside is that you do get to maintain public benefits. So if you just disinherit your special needs loved one, they're never part of your plan. They're just out. But the downside is that there's really no money there if there are special things that aren't covered by government programs. And there's that perception too of, well, you didn't love and care for that child because you chose to inherit them. It's a very harsh option, very, very harsh. And so we don't like to see that happen to anyone, rather have some good planning. Another option, as I mentioned, is that you give the inheritance to others. So give it to older brother and sister, or, spread it out amongst the siblings and tell them to take care of their brother or sister themselves. Again, no loss of government benefits, but the downside is that any money that you give away to the other siblings could now be subject to their own creditors or spouses or divorce or anything. There might be mismanagement or misappropriation, or God forbid, that child, that sibling predeceases your special needs loved one. So that can happen. I call those the unintended consequences. You think you're doing something with a good intention, but all of the unintended consequences. And I've been doing this a lot of years. We like to trust that our children will do the right thing and take care of their siblings, but families change, dynamics change. Maybe it's too much. Maybe it's more than their spouse, can take on with them. And so then we get into those situations, like I mentioned, divorce, or they want to be done. They say, I can't do this anymore, but now you've given them all this money to care for your loved one. And what do we do now? Are they going to hand that over to the next sibling who's going to care for the loved one? Then you're getting into all this gifting. So it can get pretty complicated. We don't want to just give the money away and hope for the best. So for most of those government programs, you can keep $2,000 in a bank account. So if you did get an inheritance, one strategy is to pay down or pay off debts, purchase things that are not covered by Medi-Cal. So maybe you need some dental work, or maybe you're allowed to have a car, and maybe you need tires or repairs on the car. So there are some spend down strategies that we can employ to spend down an inheritance if need be, but that's not always ideal either, because we want to make sure that, there are some resources for a rainy day. Oftentimes a loved one doesn't have a nest egg set aside. So we need to make sure that they have something, for their older years as they age and more health problems come up. Again, you can keep your government benefits, but there's no long-term access. There's no income screen. There's no way to invest that money and have anything for the latter years. If you have a disabled adult child, especially one who's older, I worked with some clients, they're in their 50s, 55 is this disabled adult child, and the parents are on into their 80s. And, we're trying to figure out a plan to be able to support this 55-year-old individual when mom and dad eventually leave us. So we've got to have a plan in place in order to do that. Now, there's something out there called an ABLE account, and hopefully that you all heard about it, because California has done a pretty big job of advertising this and getting the word out about CalAble. And if you can go to their website, you can Google CalAble. I think it's org or something like that. But an individual's only allowed one ABLE account, and the beneficiary is the account owner. So your special needs loved one would be the account owner. Unfortunately, though, there's low contribution limits. It's right around 15,000. It might have gone up to 16 this year, but you can only have 15,000 a year. And the balance is paid at death to Medi-Cal. So it's there for all of the supplemental things that you would pay for out of a supplemental account. And it's there to stretch out and have a little bit of investment over their lifetime. But at the death of the special needs individual, all of it goes to the state Medi-Cal agency. So that's the one provision that a lot of people don't like about the ABLE accounts, but it is pretty new, pretty cutting edge. And it does have a way for an individual to have some money for their latter years. And there's a lot of guidance around the ABLE accounts and what you can and can't spend it on. But it's a good product, but you just have to make sure that you understand about that payback provision at the end. That catches a lot of people off guard, and they don't like it at all. So we got to make sure that you know all of the ins and outs of that. Otherwise, you know, it could be a catch-22 and using it either inappropriately or being surprised by that payback at the end. So here are some of the things that you can pay for, you know, the qualified disability expenses. So education, housing, transportation, a training program, health prevention and wellness, any tests, anything that's not covered by Medicare and Medi-Cal already, financial management and legal fees, and then of course funeral and burial expenses. So we don't often plan for those either. So to have a fund available for that, that's an allowable expense from a CalAble account. And I say CalAble again just because that's in California, and that's the one that we are most familiar with and use the most for our families. So the benefits are that the income of it is tax-free. That it's not taxable, and there's no gift taxes either on that. And they can, the beneficiary can save and manage their own account. And it really does give them a sense of control and self-worth and some access to the money, but we have to keep in mind that it has to be used on allowable things and appropriate things. So you need really a special needs individual that has some ability to manage their own affairs and take care of their own things. So this is good for some folks, you know, who are on SSI and maybe do not have as severe a cognitive disability, have the ability to manage some money and take care of things on their own with some guidance. So it can be a benefit as well. Now I'm going to just chat briefly about special needs trusts. And this is something that I do on a regular basis. And what I like to tell people is that you stay in total control of the special needs trust. So as somebody setting this up, and I'm just going to use the word parent because that's often how it comes into being. You are the trustor, you are the trustee, and your special needs loved one is the beneficiary of that trust. So you set up a special needs trust, and you would just think of it like this, like a treasure box. It's your treasure chest. It's where you put everything that would be for the benefit of your special needs individual. So this is really how it works. The inheritance is overseen by a trustee. So somebody will keep track of it and manage it on their behalf. It ensures that the assets are being spent appropriately and that they can be used by the beneficiary, but they're not owned by the beneficiary. So therefore, they don't get disqualified from any of their public benefits. So it's there for their benefit, but they don't actually own the assets. The trust owns the assets. They're in that treasure chest for them. And they can be paid out over time as the individual ages, or as their needs change, or maybe their medical needs change, or they need some type of care in a facility, or need some in-home care. Whatever it is, that special needs trust can pay for that care. Now, the benefits are that it protects the assets, it maintains the government benefits, but it protects against financial abuse as well, because you have a trustee, and inherent in the word trustee is trust. You trust them to do the good job of managing the assets for your special needs loved one. And it can really enhance the lifestyle and the care for your special needs loved ones. The other thing is that when you have a special needs trust set up, it's not just your money as a parent that can go into it. Grandparents can contribute, siblings can contribute, others can contribute if they want, because the child, the individual never takes control of that money. it's not subject and they don't lose their benefits. So it really is a plus, a very nice vehicle that can be used. So the big plus though, and this is a big one for parents, is that it will likely avoid Medi-Cal payback. I actually haven't seen one. I haven't had one yet that had a validated Medi-Cal recovery, because the assets are never in the name of the special needs individual. They're just held in this trust. So there is no Medi-Cal payback. The assets aren't exposed to anybody's creditors. You can have some continuity, and you can ensure that the assets would be appropriately managed and not just sitting in somebody else's bank account earmarked for your special needs loved one. They actually, it's written into the trust document, they are for your special needs loved one, and it can last their lifetime. And then you can have other beneficiaries, contingent beneficiaries, that the balance of the trust would go to. Since there's no Medi-Cal payback, that money can go to the next generation, or a charity, or a cause, or the rest of your children. So it's nice in that there's think of it as a nest egg or your treasure chest there to care for your disabled loved one. But then when they pass, that money is still there and can go somewhere else in the family to carry on the legacy. There's a couple types of special needs trust, and I will again just touch on them briefly because they each have their unique circumstances. The first one, of course, is called the first party trust. So first party means it's established by the individual. And this is the type that we have to establish if we get that phone call that says, oh, my aunt just gave me $500,000, but I'm on public benefits. And if I take that money, I could lose my public benefits. So we can set up a first party special needs trust, which would prevent them from losing their public benefits. But again, very stringent guidelines. It's irrevocable. It cannot be changed. It cannot be done with. Once you set up that first party special needs trust, that's it. Literally think of it as cast in stone. And I haven't found a court yet that's willing to undo it. So you're stuck, but it's a good way to preserve that money for your ongoing care as long as you live. But the big hook is you got that Medi-Cal payback at the end. So that's a first party trust. There are pluses and minuses, but sometimes getting, a $500,000 windfall and putting it in a first party trust is the only option we have. And at least we know the money is there for the care of that disabled individual for their, as long as they live the rest of their life. They don't have control over it. We have to find a trustee, but it's there for their benefit. So no control, but all the benefit. That's a first party trust. The other type is the third party trust. So the third party trust is the one I was talking about that most parents set up. It's funded by assets that the beneficiary doesn't own. So the parent sets it up. They're the third party. They don't actually, it's not owned by the beneficiary themselves. It can be part of an estate plan for the parents, or it can be a standalone set up ahead of time to receive gifts from grandparents and the like. And the trustee has some broad discretion on how they spend that money. And you can have more than one beneficiary. So if you have multiple special needs loved ones, you could set up one special needs trust and have multiple beneficiaries of that special needs trust. So that's appealing to some families, especially those that are caring for, multiples of special needs individuals. And we do have some families who have adopted special needs individuals, and they have a family standalone special needs trust that is for the benefit of all of those children. And the beauty, of course, no Medi-Cal payback, and it's completely revocable as long as the trustor is living. So mom and dad set it up, as long as one of them is still alive, it's completely revocable. So that's the beauty of a third party special needs trust. And that's a lot of what I do. And then there is something called a pooled trust. And there are a lot of organizations out there that have pooled trusts. There's one Golden State Pooled Special Needs Trust. I've worked with them in the past. There's CCT Community Care Trust. They're based on the East Coast, but they do a lot of work here in California. So these pool trusts are nonprofit organizations, and they pool all the money. So think of it as like a mutual fund for special needs. And everybody puts their money in there, like my 25,000 and your 100,000 and that person's 500,000. And it's all in there. And then they can invest that money in big blocks. And they track all of that money and they manage the money for the special needs beneficiary. This especially is important if you have absolutely no family member whatsoever and no fiduciary and nobody who you trust to take over the management of your special needs loved one's trust when you're gone. So folks who, it's just one parent and one special needs child, a lot of times they will use the special needs trust because these are professional trust managers. Now, there is a drawback though, that, and I didn't actually put it on here, oftentimes with these nonprofit organizations, as a condition of being part of the pooled trust and then managing the money, is when the beneficiary dies, they keep the money. But it's a nonprofit and it's going for a good cause. So for a lot of people, that's perfectly okay. They don't mind that. It's not going to a Medi-Cal payback or anything. It's just going into the charity, into the nonprofit, to be able to help other individuals down the road. So a lot of interesting things going on with special needs trusts out there. Now, choosing a trustee. So I like to just give guidance that it really should be someone who can be an advocate, who will be accountable, and has a little bit of financial savvy or stability, that they can keep track of a bank statement and make sure that a purchase is appropriate. The trustee should never distribute assets directly to a beneficiary. So they shouldn't just write Johnny a check and say, here, go buy yourself a bicycle. They should not commingle trust assets with their own. So they can't just get online to their bank app and just start transferring money back and forth between the special needs account and their own account. And in the cases where we're dealing with SSI benefits, they can't make distributions for food, clothing, and shelter. That would be considered in-kind maintenance and support and could potentially reduce their SSI down the road. So we got to be really careful about that. But there's all the things that the trustee can do. They can purchase a home, household furnishings, expenses, school tuition, legal and accounting fees can come out of the trust, a vehicle, vacation travel for the beneficiary and a companion, a caregiver companion. So I have one young man who absolutely loves the San Francisco Giants, and he and his caregiver go to the games several times during the season. And they it's too far to drive back and forth from the Central Valley at night. So they get a hotel room and they stay there and they have a nice breakfast the next day and then they come home. And that's perfectly acceptable. His special needs trust can pay for that. That's considered vacation and entertainment. Can also pay for cell phone and internet. And then things not covered by other benefits like Medi-Cal and Medicare. If there are higher, maybe some higher out-of-pocket medical expense costs, or maybe there's something experimental, then certainly the special needs trust could pay for that as well. So needs are different. You want to make sure that you have a plan that's flexible enough to adjust to your loved one and then last their lifetime. You've got to be able to create that lifelong advocacy because you're not going to be here to do it anymore. And as parents, it's been your full-time job, and you have to make sure that you have your backup or your understudy or your bench. I'm using all my sports and arts and theater metaphors, but somebody that's going to be able to step into your shoes and take this on. And even if they can't do all of it, like the care of the person and the money and whatever else, maybe you can divide that up over several individuals, but you have to have a plan in place. Now, these are common misconceptions and things that I hear all the time. Special needs trust planning is poverty planning, that you're just going to impoverish the individual and they're not going to have anything. And that's not true. what it really is enrichment planning. You're trying to enrich their quality of life and preserve the assets that you work so hard to build, and then make sure they're there for the care of your special needs loved one. And not many families do this type of planning, but it's just because lack of education, lack of knowledge. It can be scary sometimes. They say it's costly. I don't know. I don't feel like it's that costly. People always ask, well, what does it cost? I will tell you that setting up this type of planning is in the range from about $4,500 to $6,500. That's about what I've seen in the Central Valley. That may sound like a lot, but in the grand scheme of things, if your estate goes to probate, that's tens of thousands of dollars. And if your loved one lose all of their benefits, that can be devastating. You can't even put a price on that. And trusts aren't for the wealthy. They really are for anybody who has these types of needs and circumstances. And then if you own real property in the state of California, we do a lot of basic revocable living trusts just to keep people out of probate court because it is so time consuming and expensive. Another misconception, and I mentioned this already, that other family members or siblings will step up and take care of them. That may or may not happen. You won't be here, so you don't know. You hope that they will, but that isn't always the case. The beneficiary might not need benefits. That doesn't usually happen. And then it's too soon to plan. And I say it's never too soon to plan. You need to have a good plan in place because you do not know what tomorrow holds or what tomorrow promises. So everyone needs to plan. SSI, parents of disabled children, non-disabled spouses, child of a disabled parent, child of a disabled sibling. So you've got a lot of people who need to do this type of planning. But, you know, I get asked all the time, well, why doesn't everybody do this? It's overwhelming. I mean, hats off to you for being here tonight. I know this is like drinking from a fire hose. You're getting a lot of information in a short amount of time, and I am just scratching the surface. So, but we want to just plant the seed, and then it'll continue to germinate, and we'll do some nurturing, and then we can look at doing some actual planning. Lack of knowledge, people just don't know, and then they don't think about the impact, and this is the impact. If you don't do anything, there could be a loss of benefits. There will be added expense, and you could end up with the wrong people in control. If you die without a plan in place and your estate goes to probate and your special need loved one is one of the beneficiaries, somebody's going to have to go to court and be approved as a guardian or a conservator of their estate. They might not conserve the person, but they will definitely conserve or appoint a guardian of the estate. And that's an additional court proceeding and an additional expense. So your now $20,000 probate just became a $30,000 probate. Caregiver burnout, if you don't have a plan in place, a lot of stress, family tension, confusion. When you lose a loved one, you lose a parent, that's already a tough time. And then to have a special needs loved one that's kind of in limbo because everybody's going, oh, I thought you were going to do it. That can be really devastating for the family. So no action at all can really, really impact your loved one. And you need some professional assistance in this regard because you got to make sure it's done correctly, and you want to have the best team in place to protect your special needs loved ones. So I encourage you to work with a qualified estate planning attorney. You might have a case manager or a worker. There are benefits advocates out there, accountants, CPAs, financial advisors, and insurance agents. And good financial advisors and insurance agents will partner with us and make sure that the plan that we get in place has all of those facets and pieces to protect your loved one, and that your assets are part of your plan overall, rather than just this patchwork of things that are going on. If you name your special needs loved one as a beneficiary on a life insurance policy, for example, and they don't have the capacity to fill out that paperwork and receive those funds, somebody may have to go to court and get a conservatorship of the estate to claim those funds on their behalf. So again, devastating consequences. I put this up here again. If you have any questions and want to talk more about this, I am happy to help. And you can find us on Instagram and on Facebook and pretty soon on TikTok coming up. So we're just going to be all over. I do like to offer free consultation to anybody who's done a webinar. And certainly I offer that to all of our UCP community because I do believe this is so important. We just ask that you not put your head in the sand and try to schedule that appointment within the next 30 days. Give our office a call and tell Jack that you did our webinar on special needs and you want to come and just have a conversation. I'm not trying to sell you on anything. I just want you to have the information so that you are empowered and have all the tools you need to make good decisions on behalf of your family. And what you would expect is that we would just lay out the options, see what makes sense. Maybe it's Cal-Able, maybe it's a special needs trust, maybe it is a pooled trust, maybe you have some other plans in place, but we'll just kind of walk through all that and then put something into action because no plan is devastating. And then, of course, we want you to educate others. You all are a tight community. Parents take care of each other. I'm glad to hear there are support groups through many organizations. And you got to share, you could say, oh, I heard this lady at UCP talk about these special needs trusts, and we're going to look into that. Maybe you should too, because we've got to get the word out. Trusts are not just for wealthy people. They're there to protect people. So friends, families, business associates. I do a lot of speaking at churches and then events such as this for the community through UCP, and I've done society before. So we want to make sure just to have education and knowledge out there. All right, well, I know that that's a ton of information. Are there any questions?
So there's a question in the chat. It says, how much time does it take to get it started to finish, from start to finish?
Yeah, start to finish. Once we have our consultation and you've told me what all your choices are, we can get it done in about 4 weeks. That's our timeline right now. So less than a month. If there's an emergent situation, like somebody's in the hospital, we can scramble and get it done a little bit quicker. But we like to, make sure that we're thorough and take our time. And so about 4 weeks end to end. Any other questions? You can put them in the chat or unmute and just ask away.
There's another question. How long is the typical consultation?
Yeah, I allocate an hour, but if we go over that, that's fine. And I can do them on Zoom too. I know that a lot of parents are caregivers and they don't want to leave the house or they don't want to hire, a respite worker to come in for that amount of time. So I'm happy to do Zoom as well.
Gina?
Yeah.
I have an adult son who has been conserved by the county. He has suffered from SMI. And my wife and I would like to set up something like in case something happened to us, the house, he can't have the house because he can't take care of himself. Is there something we could do for him? Like, could the house be sold and put in a trust?
Yeah. Yeah, it absolutely can. So your trustee could sell the house and then put the money in, leave the money in your trust, and then he would be the beneficiary of that trust for special needs.
Okay. But with him being conserved through the county, he won't lose his benefit, would he?
No, he won't lose his benefits because these are your assets. They're just going to be there for his supplemental needs. It's not going to replace anything the county is doing for him.
Okay, thank you.
You bet. Any other questions? All righty. Well, thank you all for joining us, and thanks to Chris for putting this together. I hope it was informative and useful. And again, if you have any questions or want to reach out and do that consultation, I encourage you to do so. Happy to help, and I look forward to meeting with you.
Thank you, Gina, so much for doing this again. We really appreciate it.
You're very welcome. Thank you.
Thank you all for joining us.